It's 4:30 Swiss time, so we will respect Swiss tradition and begin almost on time. I'm very happy to welcome you. I'll be your host with Karin Lorez here today. So my name is Gabriel Jaccard. I'm a PhD candidate at the University of Geneva. I'm a consultant and I'm the co-chair of the Regulatory Working Group, which is the group in the Crypto Valley Association, taking care, as its name suggests, of the legal question relating to blockchain, and there are many of them. One of them that struck us the most during our last call, and where the reason why we wanted to make this small event was that we felt that we could have some legal clarity with regard to the decentralized exchange question. So basically, there are news. The decentralized exchange is a hot topic right now. There are many legal questions coming up, and we are happy to provide you with a great panel of experts, technical and legal experts, that will hopefully answer all your questions in this regard. So you have the possibility to ask questions at any time during the session. So you have a Q&R tool linked to Zoom. It's not a mystery to most of them, so I'll not epiloguate on that one. But we will ask your question during the talk mediated by Karin. So feel free really to ask any question, and we will select them so that you can have a more interactive and more direct talk with our speakers. So without further delay, I'll just introduce you to the few participants we have. The first one is Alexandra Bertomeu-Gilles. She's our technical expert. She works as a risk manager at Aave, and she's advising also a project in the crypto space that she will talk to you about. The next speaker is Daniel Roeser. He's our legal expert from the US side from the common law, with a common law perspective. He's a partner at Goodwin and Procter LLP, and he's specializing in securities and blockchain law. Last but not least, but from our speaker side is Reto Luthiger. He is a Swiss legal expert with regard to decentralized exchange and blockchain related questions at MLL, Meyerlustenberger, Lachenal. Last but not least is the mediator, Karin. Karin Lorez is the co-chair of the Regulatory Working Group. She's also a lecturer at the University of Zurich, and she has her own consulting firm, always in between Zurich and Dubai. I've talked too much. Now I'll hand it over to Karin so that we can get down to the heart of what are DEXs and what is all the fuss about DEXs. Karin, you're on.
Thank you so much, Gabriel, for this introduction. Hello, everyone. My name is Karin Lorez. I'm very happy to be the moderator of this panel. And I'm super excited about discussing decentralized exchanges. It's a super hot topic. Everyone is talking about DeFi, about decentralized exchanges. So this space, the DeFi space, has definitely taken off. We, as a regulatory working group of the Crypto Valley Association, thought we should shed light on it from a legal and regulatory perspective, but also from a technical perspective, because often it really gets forgotten. And I think it's very important that we talked about what does decentralization, or what is the notion of decentralization actually mean? And I would like to start asking the question to Alex. What is actually the difference between a decentralized exchange, a DEX, and the centralized exchange from a technical perspective, maybe more?
Yeah, so the two are quite different, and decentralized exchanges are pretty new as well. So the technology behind decentralized exchange is less advanced. So just in terms of process, the key difference is in a centralized exchange, the data is processed internally in dedicated servers with their own security processes. So that means that the client's funds are escrowed and managed within this centralized system. And so the entity behind the exchange is in control of all the information and also in control of the assets listed on the exchange. On the other hand, so decentralized exchange is a peer-to-peer marketplace on the blockchain. So all these operations occur on these public blockchains and are visible by everyone, as well as the smart contract and the operational organization behind it. So some of the key advantages of that is that because it's on the blockchain and it's non-custodial, so the customer as a customer, you don't have to give up control over your funds. And it's also peer-to-peer. So it's permissionless. Anyone can participate in a decentralized exchange. There's two key ways to participate. Either you can be a liquidity provider. And so that's basically you become the exchange and you provide liquidity to the exchange and you get some of the fees. Or either you just use it to exchange funds, which you can choose both a centralized or decentralized exchange to do that. So now the real technical aspect of it is how these funds are exchanged. And so that varies from a centralized exchange where actually this technology has been used for decades on traditional markets. And so typically centralized exchanges, they use a technique called order matching. And so it's a system which matches all the buy and sell order. It's quite interesting. If you look at it, it creates kind of a pyramid structure. And you can see all the different transaction volume at different price levels. And so effectively the liquidity can be waiting to be exchanged. So the transactions can happen really, really fast within milliseconds sometimes in the extreme cases of algorithmic trading. So that on the other hand, so that's kind of the challenging part to implement in a decentralized manner. And so decentralized exchanges are also called automated market makers because there's basically a mathematical algorithm that describes how the tokens can be exchanged with each other. So you probably also heard the concept of bonding curve in the cryptocurrency space, and it's the same concept where a curve defines the relationship between token A and token B. And so typically in this curve, there is an invariant variable that's called K, and it's a variable that stays the same while all the other variables can change. So the price of the tokens, the balances of the tokens in that liquidity pool change, but then it has to reconcile back to this invariant. And it's a bit, if you know a bit about physics, it's a bit like a hydraulic system where one side reduces, the energy goes to the other side, which increases to balance things. So typically, for example, Uniswap, which is the biggest decentralized exchange, the formula is quite simple. It's X times Y, so balance of token A times balance of token B equals K. And so that's it. That's the mathematical formula that allows to exchange now, that has allowed billions of exchanges. So different decentralized exchanges have different formulas which have different benefits or lead to different risks. And this is evolving really fast with many new decentralized exchanges emerging and new ways to do it. And so one of the announcements and one of the latest releases is Uniswap v3, which in addition to this constant formula also introduces kind of an order matching mechanism similar to centralized exchanges where users can provide liquidity to specific ranges.
Mm-hmm. So, and as you said, so it's very interesting. So they're like developing constantly, right? I mean, Uniswap, for example, it's already version 3 and they don't exist for a very long time, right?
Yeah, exactly. So version 2 was last summer and just before last summer, now version 3, but It's the beginning of this new technology, and so there is a lot of improvements to be made, and so that's why it's progressing so fast. Basically, one of the big dangers of decentralized exchanges, in particular for liquidity providers, is impermanent loss. So to return to this invariant, the algorithm will do it whether it loses money or it makes money. So basically, all the arbitrage that happened on the exchange, the liquidity providers kind of carry that cost.
I find this topic very interesting, and maybe we can discuss it later when we talk about liabilities, because this is a very interesting topic, and I'm not sure if a lot of people know about it, which would be interesting to touch on it. I would, as you said, and I would like to pick it up. So unlike traditional exchanges, a DEX has no possession of an order book or custody. That's what you said. Instead, they use there is a peer-to-peer transaction. So meaning that the users, they transact directly with themselves, right? And there is no central server who does the matching or whatsoever. So from a regulatory perspective, I was wondering, or maybe also other people were wondering, how are DEXs actually regulated? And do they fall under any specific regulations? Are they licensed, or do they actually need a license, like a centralized exchange or a traditional exchange? And if not, when do DEXs fall under like the regulatory framework or requirements? Maybe Reto, from a Swiss perspective, it would be interesting to hear what's the Swiss perspective.
Yes, of course. The Swiss perspective is actually, we have our regulatory principles are basically that we apply our existing laws to all types of exchanges. We look at the function, what functions like an exchange. So if it functions like an exchange, it must also be regulated as an exchange. That's the basic principle of the Swiss regulator FINMA. And a second principle says that the technology is not relevant. We have a technology neutral approach. So therefore, usually we go and say, we also have in Switzerland the usual 3 pillars of different exchanges. We know actually based on the existing legislation, we have stock exchanges, multilateral trading facilities, and organized trading facilities. So what functions like that must be regulated like that. Now, we all know that with DEXs, we have different levels of decentralization. We have DEXs where at least some functions are organized in a central way, but in a perfect world, there would exist the perfectly decentralized exchange. Now, one could think of that Switzerland, with just releasing its new DLT law in August of this year, will solve this kind of problem with regulating decentralized exchanges. However, also there, we have a fantastic new type of exchange license covering DLT-based exchanges, obviously, but also there it is focused rather on centralized or at least partly decentralized providers, because as in the existing legal system, the regulator always connects to a kind of operator, being an individual or a company, but we always need an operator where we can connect the regulatory duties. And that's exactly where the fully decentralized environment gets actually in conflict with the principle of the regulator to regulate exchange activities, because this is a financial market activity actually. If there is no person or operator we can connect, then who can we regulate in the end? And there's another question, if it's would be really perfectly decentralized, then we even don't know which jurisdiction is actually responsible for regulating this exchange, because that's regulation. Regulation is always lies in the responsibility of every jurisdiction. So this is the main problem we have. So the short answer for fully decentralized exchanges is actually that as of now, they are not really regulated. And also the Federal Council in Switzerland wrote in his explanatory reports to this new law that he had not intended to cover fully decentralized exchanges. However, Switzerland will follow international developments and maybe also try to regulate. And as of now, we see that the Swiss regulator FINMA already tries to catch somehow these DeFi structures, be it decentralized exchanges or other DeFi structures. Somehow they just at the beginning of this year started to escalate some really precedent cases internally, where they really have a close look at decentralized structures, and they try to find some sort of link to the structure itself. Maybe it's not a classic operator, but maybe they search for elements like someone who receives fees of every transaction, for example, someone who operates at least the login website and has a permanent contractual relationship to the user. Such things they are looking for at the moment, and then they try to construct at least something like this person is supporting the exchange somehow in doing the exchange activity. That's like they try it, and we also see it in the AML area, where we have first drafts with such approaches which FINMA tries to regulate, and we see it also in the draft consultation report of the FATF regarding VAs and VASPs. So that's where we stand.
We will come to that later as well, to the FATF guidance, which was just recently published. But the interesting thing that you're saying is that the new DLT framework, which Switzerland has published, doesn't actually regulate fully decentralized exchanges, right?
Exactly, yeah. This is the case because I guess the easy answer is that also our administration did not know how to do it back then.
Yes. Well, I thought maybe they forgot it, but they didn't forget it because they explicitly mentioned it, right?
Yeah,
and said that it's out of scope, which is very interesting. Yeah. Then I would like to hear the US perspective on DEXs. So what is the US perspective? Is a DEX defined as an exchange under the securities law, or is it subject to any regulatory compliance or legal compliance requirements? What is the US view, Daniel?
Sure. Yep, sure. I mean, as you mentioned, decentralized exchanges are relatively new, and certainly the current, kind of increase in activity around them is very new. But I think to give you at least an indication of where the U.S. regulators may be, it's helpful to look at a settlement involving the SEC, which is the U.S. securities regulator, and it's called Ether Delta. Now, it came out in November of 2018, so obviously a couple of years ago now, and as Alexander was describing, the technology has changed probably significantly since this project. But I think it gives you an indication of at least how the SEC was looking at these issues at the time, and at least one approach they may take going forward in thinking about exchanges. So Ether Delta, just to give a little bit of background, billed itself as a decentralized exchange, right? They described themselves as a decentralized exchange, and they asserted that there was no exchange owner holding the funds. The SEC looked at that issue and also ultimately reached a different conclusion in terms of how decentralized the exchange was. But I think the analysis is what's instructive from a US perspective, right? So under the US securities law, just a little bit of background, it's unlawful for an exchange to effect a transaction in a security or to report a transaction unless the exchange is either registered as a national exchange or is exempted from that registration. So that's kind of at the high level what the legal standard is. And then the question becomes, well, what's the definition of an exchange under US law, which is exactly what you just posed. And that definition is relatively broad, and it captures any organization or association or group of persons which maintains a marketplace or facilities for bringing together purchasers or sellers of securities. Right? A very broad definition that is meant to cover a variety of exchanges. That is applied in the US using what the SEC describes as a functional test, and it really has two parts. The first is this enterprise bringing together for orders of securities multiple buyers and multiple sellers? That's kind of part one. Part two is there an established non-discretionary method for these transactions, right? Something that's observable, established, happens time and again. Now, applying that test, the SEC concluded that Ether Delta, notwithstanding its description as a decentralized exchange, was an exchange that was subject to the federal US securities laws. And it did that because it felt that Ether Delta, notwithstanding its description as that decentralized exchange, really met both components. It was a marketplace. It brought together orders of buyers and sellers. And the SEC found that those transactions included securities because the underlying issue there were these digital token securities, and obviously the US has a very different framework from Switzerland and the EU in terms of what a security is. But under US law, you have the concept of an investment contract. So if you have an exchange of money, if you have kind of common interests, commonality, and you have an expectation of profits based on the efforts of the promoter, in many cases the founder, that can be enough to constitute a security under US law. And so from the SEC's perspective, Ether Delta was transacting in or facilitating transactions in tokens that under US law were viewed as securities. Okay, so that's the first prong of the functional test, satisfied in the SEC's view. Have a marketplace, buyers and sellers purchasing what the SEC considered to be securities. The second component was, well, was there a sort of rigorous and predetermined routine for these transactions? And in the case of Ether Delta, they had a smart contract that operated on the Ethereum blockchain. And that smart contract constituted what the SEC called an established non-discretionary method of trading. And so that was the second prong that was satisfied. And so from the SEC's perspective, that meant that Ether Delta was an exchange that would be regulated under US law. And then the question became, okay, well, was it registered? No. Was it subject to any sort of exemption? No, at least none that it had applied for. And so therefore, from the SEC's perspective, Ether Delta was in violation of the law and was subject to liability as an unregistered exchange. And so the last question then became, well, who's actually liable here? Because Ether Delta had been sold. And in this case, the SEC actually held the founder liable. And the SEC's thinking was that the founder there exercised complete and sole control over Ether Delta's operations. He'd written the contract that was on the Ethereum blockchain. He was the one who controlled those operations related to trading, and he should have known that those actions would have led to violations of US law. So in this case, they went and looked at the founder. But this all begs the question, which I think we're going to talk about next, as to whether in fact this was a decentralized exchange, right? From the SEC's perspective, the founder controlled Ether Delta. And so one might argue, well, this is all well and good, but this isn't November 2018, and really it was a centralized exchange, notwithstanding the description. And I think that then raises the questions of decentralization that I imagine, Karin, you may want to jump to next.
Exactly. Yeah, that's a very interesting question. What does decentralized mean? So how does one measure that? Whether it's fully decentralized, what Reto already mentioned, and when isn't it not really fully decentralized? Can you give us some guidance there? Because somehow people maybe get a bit lost. I mean, what is it just if you label it as decentralized, is that sufficient? Of course not. But when is it really and truly decentralized? I really want to know that from a Swiss and from a US perspective, and also from a technical perspective, which could be quite interesting. Who wants to go first? Alex?
Sure. So from a technical perspective, I mean, being decentralized, so I think it's about the level of control a central entity has over the decentralized exchange. So typically, who controls the listing of new assets? Is it, and I think in the case of Ether Delta, for example, that was one of the specific points identified. The founder controlled the assets listed on the exchange. Whereas if you look at one of the most decentralized exchanges today, Uniswap, anyone can create a new liquidity pool and list a new asset. So operationally, basically, all the processes and the upgrades have to happen, not just from the team behind it, but also from the community and from different contributors.
Reto, what is your view from a Swiss perspective or broader perspective?
Yeah, of course, decentrality in decentralization in connection with exchanges usually means we have a look, actually, it's what David Daniel told you before, that also in Switzerland, the DEF simultaneously puts together bids between several participants, and if they conclude a contract based on non-discretionary rules on the platform. And we have actually, I would say, if we have a look at the value chain of an exchange, it's order matching and execution, clearing and settlement. And we must have, from a Swiss perspective, a look at every step of this. And when I remember back, we had the first DEX projects I had, clients, they always told me, yeah, we are fully decentralized. And in the end, we saw that, yes, they have P2P functions. So the fund flows were between the users and not over the platform. So that's good, decentralized fund flow. But they did an order book matching like a centralized exchange, a classic one, over the platform. So the bid and asks have been connected to each other on the platform, and therefore this one was not was obviously not fully decentralized, especially the matching function. So with the fully decentralized DEXs, as Alex also explained, we have also the matching process is not done by an order book, but it's simply with this algorithm and the liquidity providers and swaps. It's functioning in a completely different way. So also there, we then don't have this matching process on the platform. So it's completely another mechanism. And that's basically what we also from a legal point of view see as fully decentralized. Further, as I told you, the regulator is simply also looking for other connexes now. So if you want to really be fully decentralized, it must actually be simply the software code running for itself without any intervention and without any gatekeeper, and actually also not anyone having control over this kind of software or smart contract. That's at least from a Swiss legal perspective.
Yeah, thank you. That's interesting, very interesting. I mean, Daniel, if I, as your client, let's say I'm your client, what would you say from a US perspective, so that I am really on the safe side and don't follow like previous projects that actually failed or were not regulated?
That's an exceptionally challenging question. And I'll explain why. So in the US, as I mentioned, and as Reto knows, it's a very different legal structure, not just because it's a common law structure, but just the approach to digital assets in the US is very different. It's actually governed by a test called the Aave test, which was set forth by the US Supreme Court, highest court in the United States, in 1946. So as you can imagine, it was not designed for cryptocurrency, digital assets, any of the issues that we're talking about now. The concept of decentralization actually first came up came up in a way that was well publicized in the US in mid-2018. And that was in the context of ICOs and the question of whether offerings of digital tokens would be securities, or whether, if they were sufficiently decentralized, they were not. And so one approach might be to think about whether decentralization in the context of decentralized exchanges could be thought of in the same way. And so you might then ask, okay, well, what did decentralization mean in the context of ICOs? And it was never defined, has never been defined. But the two touchstones that I think folks in the US think about are Bitcoin and Ether, right? Those are projects where at least the view is that the founders at this point are no longer required for the project to run, and not just on a technical level, but also kind of on a practical level when we're talking about use cases and the number of operations, transactions, et cetera. And so, you know, there may be others, but those are two that at least the US regulators have pointed to either explicitly or through inaction in terms of enforcement actions as examples of decentralized projects. And so one then might think about, in the context of decentralized exchanges, the same sorts of principles. If you have a founder of a decentralized exchange, is that founder still entirely or primarily, you know, pick your adverb, responsible for the decentralized exchange in its operation? Or has it developed sufficiently that the founder could and in fact did step back such that it is decentralized and is running without, you know, the significant influence or control of that founder? Ether Delta, which I talked about a few minutes ago, is an example where the SEC was of the view that the founder was in fact exerting complete control. So label it decentralized or not, in their view it was centralized. And so then for future projects.
What if the founders left? Let's say they left the project, what happens then?
It's a very interesting question. And I think it depends in part on how that project evolves. So for example, there are projects where there may be a few entities or individuals who are not the founder, but who are ultimately exerting control over the project in terms of approving technical amendments, potentially approving economic amendments if you have governance tokens. And you could see a scenario where you know, that they may be considered to be exercising some level of control. I don't think that's something we've seen in the US, and I think there'd be arguments why that wouldn't be appropriate if these folks were not really controlling the network. But that could be one issue. You know, another issue could be, even if the founder left, under the US securities laws, depending on the founder's activities and the period of time when he was controlling the network, he could still be liable in some way, right? It's almost the converse of Ether Delta, where the company left, and so they went after the founder, but you could see the opposite happen in some scenarios as well, I would think. It hasn't happened, at least that I'm aware of, with respect to a US regulator, so it's kind of an inference, but you can see that happen.
Yeah, I just want to ask Gabriel, do we have any questions so far from the audience?
Yes, we have many questions from the audience. I picked one arbitrarily, I'm sorry guys, but we have a question from Tobias Dahlberg, and he says basically that do you believe that if the centralized exchange or the semi-decentralized exchange are regulated too hard, people will inevitably go towards more and more decentralized solution, hence making the state lose its grip, you know? So just create the platform, lose the key and the control, make the money, you know, in a derivative way. Do you think it affects the regulatory outlook at some point?
Interesting question. Who wants to take it?
I mean, I guess I can start. And the short answer is I don't know. But I guess a couple of thoughts would be that I think the point about innovation and regulation stifling innovation is certainly one that's been made in the US, as I'm sure folks on this call are aware of and discussed at length. But I think that does need to be balanced against an understanding what the regulator's role is, right? The regulator's role ultimately is to protect investors. And so on some level, there is a balance between innovation, but also making sure you have a sufficient regulatory framework in place to protect investors from projects that from which they need protection, right? In the US, I think back to the ICO era, and there were a large number of those projects that were ultimately proven to be fraudulent. And I think that illustrated, on the one hand, you want regulatory clarity, absolutely, and you want a regulatory environment that doesn't stifle innovation, absolutely. But at the same time, you want an environment that protects investors so that they don't find themselves in a situation where unwittingly they are put in harm's way because there isn't a sufficient framework in place. And obviously different countries are doing it different ways. And I imagine my sense is that most countries are still trying to figure out exactly the best way to do it. But I would just say that there's a lot of focus on stifling innovation, and rightfully so. But I think there also needs to be focus on protecting investors, which ultimately really is, at least in the US, and I imagine in Switzerland as well, the principal focus of the regulator.
Definitely, yes. And maybe I want to hear Alex's view. You're very connected to the space, right? You know a lot of people in the DeFi space. What do you think? How would you answer the questions? Will people just try to go more decentralized? So ultimately decentralized and lose the key or whatever? What do you think? Is it?
Yeah, I think that's clearly the direction the space is going, and protocol after protocol, whether it's a decentralized exchange or other type of DeFi protocols, I think it's clear that the decentralization is in process. It's something that doesn't happen in one day because, especially like over the weekend, actually, there was a vulnerability discovered in a smart contract that was 4 years old. So if there is a vulnerability and the protocol is fully decentralized, it's quite hard to patch. And so actually, decentralization is a process. It's an ideal. I think a lot of protocols are taking it really seriously. I would like regulators to be more considerate as well for the challenges that come with decentralization. And it's true. I mean, the tendency also I've observed in the space is there are more and more anonymous contributors. And so, that is to protect oneself from regulation mostly. And it's risky because in the end, the loser is the consumer, which, is not protected, there's not that identity layer that provides some sort of consumer protection. So.
Yes, I think that's a very good point. I mean, we should also, or the regulator should not forget that there is also, I mean, maybe he pushes all the projects into a direction which isn't necessarily the best for the market or for the investors as well, which is very much riskier than if it was just a semi-decentralized project, right? Reto, you wanted to say something, I think.
Yes, I can simply, I agree to Daniel's and Alex's points, actually. And it is the case, we have on the one side that the regulator looking out for the investors' protection. On the other side, we have in the ideal fully decentralized world, it's actually not possible to enforce. But all the gray areas are going to be difficult to handle, and it's also it's a fact. Licensing and regulation imposes huge costs on the operator and on the clients or the investors. So investor protection is not only protects them from faulty or fraud or whatever, but the regulator should actually also consider the costs he lies on the investors in the end. And yeah, unfortunately, this is not so much the perspective of the Swiss regulator, to be honest. Swiss regulator says investor protection, that's it. And we are not here to foster the competitivity of the Swiss financial market and so on. So that's a little bit the pity, but in the end, there should be some sort of a balance, actually.
Exactly. I see it exactly as you, Reto, but I think that it's very similar in the EU as well, and this has become very prominent after the financial crisis, where it was all about investor protection. So investor protection is always much heavier weighted than whatever innovation or anything else. So this is what I've seen in the past over 10 years now, yeah, which is yeah, a bit sad, to be honest. Yeah, Gabriel, do you have any other questions that you would pose or like to pose from the audience?
We have many questions from the audience. One of them, which came back a few times under kind of different format, for instance, from Thibaut or from Kalol. Basically, the question is, the regulation is kind of crushing the blockchain decentralization. So do you believe that the regulation will kind of make decentralization not great again? I mean, do you believe that actually the regulation will actually disable decentralization?
I want to hear this from Alex.
So I'm not sure I catch the full question. So operators or founders would just be tempted to, what do you mean disable decentralization?
So the fact that we have the regulatory requirements coming from the regulators now, we have more and more detail that decentralization will in the end be impossible from a legal standpoint. That's basically the idea of the question.
Yeah. Well, yeah, I mean, you know, I think from a legal standpoint, you know, it's definitely more challenging every year. Hopefully, you know, everyone is understanding each other better. You know, the decentralized protocols understand the need for regulation and for consumer protection, and same thing, regulators understand the need for decentralized services, because also, like, you know, we're constantly reminded of the weaknesses of centralization, and so, you know, there are a lot of risks with decentralization, but, you know, centralized entities also you know, leak information, suffer hacks. So it's you know, like, I think, you know, it's not it's important to keep mitigated approach and, you know, the full picture rather than fall into one or the other.
Mm-hmm. What I've seen in the last couple of weeks or months even, or years, that I talked to the space in general about decentralization and about DEXs or DAOs or whatever, a lot of people are of the opinion that using basically a blockchain to create an exchange without central operation and so on doesn't remove the creator's responsibility. And we already touched base on it. Do you think that is right? I have the impression that this is quite like quite a strong belief in the space, that as long as you like say, well, I don't have like any like central operations, so that's why I'm not responsible for anything. I don't have any liabilities. So maybe we already talked about responsibilities, but maybe the liabilities. Do you see like any issues there? I mean, just to dive a bit more deeper into the topic of decentralization, do you think there is a risk for someone who sets up a DEX without being fully decentralized on the liability side? Let's say from an investor protection perspective or whatever.
I'm happy to go first. I think from a U.S. perspective, the short answer again is, I apologize for not being able to be clear, it depends. And it depends on when it's set up, how it's decentralized. I mean, I understand as a technical matter, one can implement a protocol that is decentralized, but as a practical matter, when that has to get upgraded, is it the founder who's doing the upgrading? Is it the community? And if it's the community, is it a broad community, or is it a community that really consists of 5 to 10 folks who are doing the action? Right, there is a whole spectrum, as Reto described, a very wide spectrum and gray area of decentralized to centralized. And so if you're in that gray area, then I would say that you potentially in the US have exposure, have liability exposure on a couple of different levels, right? If, for example, you are something like Ether Delta, maybe less centralized, but that sort of setup, Or even if you're a more decentralized exchange, but you're trading what are considered in the US to be securities, which are many digital tokens, for example, you may be considered an exchange. You may be subject to registration, and if you don't register, you could be liable. That's kind of the story of Ether Delta. In addition, in the US, if you are engaging in secondary transactions in unregistered securities, again, what could be many of the tokens, that could be a second source of liability. And so the question of whether the founder could be liable for either of those, and there are other sources of liability as well, but the question of whether the founder could be liable for those, I think, again, comes back to the question of A, what does decentralization mean, and B, how do you measure it as a practical matter in addition to as a technical matter? Because clearly, without the technical decentralization, which is a threshold, without that, then you have an issue just right off the bat. But let's assume you have technical decentralization. How about the operation of the exchange, and how centralized or decentralized is that operation, or the use cases in that exchange, right? All of those factors, I think, at least from a US perspective, regulators would be likely to look at. And that would all factor into the amount of risk a founder may have.
So we're basically coming back to what is decentralization? What does decentralized mean? So Reto, what is your view? Is it similar in Switzerland as well? Or you have already had some experience with FINMA. So FINMA goes after some decentralized projects, but why? Do they want to find out if they're really decentralized, or what is the reason?
Yeah, in the end, the basic elements are what Daniel already told us, and I told you before, with this all gray area cases with decentralized, centralized, whatever. And in Switzerland, you have this, as in the US, I guess, this basic also criminal principle that if you operate an exchange or something that needs a license and you don't have this license, you are getting criminally liable. Actually, that's the first one. That's more kind for the criminal prosecutors. FINMA, as told before, wants to protect the investor. And if we have some central elements, it's always, we all know that centralized elements are very, it's easy for fraud, it's easy for misfunctions or whatever, and FINMA wants to prevent that. And that's why FINMA has a look at it, and if there's a central operator, then it's clear it's going to be regulated. And FINMA has a very wide approach, even if she sees that we have not a classic operator, but maybe we have someone who provides the codes. Then we have someone who's operating the login web page, and we have a third one earning the fees. And FINMA sees that they somehow work together, then they simply applies the group approach to them, and maybe also enforces its kind of regulatory instruments it has in the end. So it's also this kind of group approach which gets also very popular on the regulatory side for such decentralized structures. We see that with FINMA, but we see that also in the FATF's proposal.
Yeah, this is very interesting, because usually you go after one person or after company, right?
Yeah.
If there is no company, so the approach now is, which is something new, is just, okay, we just go after a group of people who seem to be involved in the project, or who seem to have a role or an important role, right?
Yeah.
This is very interesting. Okay. Before we go to the next topic, which will be AML, Gabriel, maybe you can pose other questions, like additional questions.
Yes. Two small questions, maybe one for Reto. Nobody is from the EU here, but someone was interested to know if MiCA was solving the issue of decentralized exchange. So maybe you can give just a quick answer on that. And then we have two questions linked together that are related more to a topic where Daniel would be competent, I guess. That is the SEC reach on a fully decentralized exchange. Would SEC find itself competent? What is the extraterritorial competence of the SEC with regard to DEX. So I'll leave Reto begin and then leave you continue, guys.
Thanks, Gabriel. To be transparent here, I really don't know the answer if DEXs are regulated under MiCAR. I know that MiCAR will introduce at least a full framework for all kinds of crypto assets. It's the separation between what falls under MiFID, stays under MiFID, and now everything other, including stablecoins, are being regulated. And at the same time, they will also amend its regulations for trading platforms, that's for sure. But I really don't know if they are really also able to catch fully decentralized structures. I don't think so, but
yeah, and on the latter question, it's interesting that question was asked because when Reto and Karin were talking about the jurisdictional reach of various countries and how it applies to decentralized exchanges, I actually had a similar thought. It's a very interesting question. Like Reto and his question, I would say the short answer is I'm not sure I know how they would do it, but I think it depends on, again, the facts and circumstances. So as an example, if the decentralized exchange, while decentralized, is being run, however we're defining that term, out of the US. So think the technology is based in the US, even the actors are all over the world. I think that would be a scenario where one might think it more likely that the SEC would seek to assert jurisdiction. If you're in a scenario where you know, the actual technology is being run out of Europe or Asia, non-US country, then I think a second question would become, and this would also apply even if it were run out of the US, where are the parties entering into the transactions? And if the short answer is, well, everywhere, because it's decentralized, so some in the US, some in Europe, I think one might expect that the regulators would at least assert jurisdiction over those parties or those transactions involving a US party. Now, the next question would likely be, well, fine, but how do you figure that out if you have anonymous folks engaging in transactions, as Alexandra said, and if you're not really sure which transactions are occurring where? And I think that's where it becomes, from a technical perspective, increasingly challenging. And so I think that's an issue that the regulator would have to grapple with. But I think, you know, depending on the facts and where the project's located, and on the assumption that at least some of the folks are located in the US, I think one might expect that the regulator would believe that it would have jurisdiction at least over the subset of transactions where one of the parties is in the US. And how you figure out which transactions those are, how many transactions those are, I think those are very challenging questions. That would be a case-by-case sort of analysis.
Mm-hmm. I see. So what I can say is that it's not an easy topic, also from a regulatory or from a regulator's perspective, I have to say. So the regulator just tries to get like bits and pieces and tries to grab some people and to make them maybe liable or responsible. But it's very interesting that the regulator really doesn't exactly know what to do. Which hands me over to the next topic, which I'm particularly interested, which is AML. So we haven't talked about the AML issues, or maybe not issues, on DEXs. And the FATF latest guidance, which Reto already mentioned in the beginning, essentially defines like non-fungible tokens as virtual assets. And the updated version also discusses like stablecoins, DeFi projects, non-fungible tokens, DEXs, and they're like DEXs are considered as VASPs, as virtual assets providers. And which means that basically the revised guidance suggests imposing AML and KYC towards DEXs or DEX applications. What is your opinion on that? Alex, maybe do you think that's a good idea to have AML and KYC rules towards DEXs?
Yeah, actually, France has passed such a regulation requiring, I think, in the future, in the next year or so, for all crypto wallets to be like linked to an identity. And I struggle to see how this can be implemented today, given how far we've already come. And you know, I think, you know, actually most cryptocurrency users now, you know, they have various wallets and you know, I mean, you know, they are declared. I mean, although they're not directly AML, because you need to declare your capital. So in a way, like, the regulator does have some information about who owns what, but yeah, I'm not really sure. I think this is really opposed to the decentralization ideology that, you know, aims for permissionless system, because, you know, today, like, well, we're in Switzerland, we're in London, so we're privileged, but actually billions of people don't have access to financial services, and that's partly because of who they are, where they come from, sometimes which religion they belong to. So if you start putting AML and KYC, that's gonna really kill the ideal of a universal access to finance.
Daniel, do you have an opinion on that, on FATF's new or latest guidance? Or the proposal, let's put it this way.
Sure. I don't have an opinion on FATF specific on the broader, you know, it's no less of a US focus, but on the broader question of KYC, AML, and in the US, there's also what's called OFAC. So there are a list of countries, you know, residents of which, aren't able to kind of transact in securities in the US. And so those different kind of regulatory layers exist in the US. And so for projects that are going to comply with US regulators, and these are not the SEC, these are other regulators, you know, KYC, AML, and then these OFAC requirements come into play. And so I certainly take Alexandra's point that it may be counterproductive in terms of making, or at least maybe at odds with a better way to say it, in terms of making, you know, digital currency available to large numbers of folks who don't have access to it. But kind of from a US regulatory perspective, I think that as a general matter, KYC, AML, and OFAC would apply. Now, the next question becomes, well, who does it if you have a truly decentralized exchange? And that, again, that comes back to the gray area we've talked about at some great length, right? It's how decentralized is it? And would you want the founder to do it? And if the founder does it, does that undermine the argument that it's decentralized if the founder is actually doing it? All of which are very good questions and kind of lead back to one point, which isn't directly related to AML, but just thought I would flag. In the US, you see actually even discussion and perhaps disagreement among some of the SEC commissioners about how to deal with getting from A to B. A, when a project is launched, to B, when it is decentralized as a practical matter, right? Because in many cases, even once it's launched and even once the technology is purely decentralized, getting to what folks would consider decentralized as a practical matter can take some time, development of users, all the rest of it. And so there's discussion, and there hasn't been any sort of resolution about how to deal with that issue, because if you were to look at most projects early on, I would imagine folks might say that they were not decentralized. I think folks might say that about Ethereum at the time of its launch. If you were to look at it later, maybe a different story. And so then the question becomes, well, what do you do in that interim period for projects that are trying to get to decentralization? And I think that's a question in the US that I think folks are still thinking about, perhaps in Switzerland and the EU as well. And it relates to KYC, AML, and OFAC in the US in terms of does it need to be done, who should do it, and who's responsible if it's not done. But it also relates more broadly, I think, to the issues we've been discussing.
And as you said, and if KYC is done, does it then lead to the point that the DEX is not fully decentralized again? I mean, then there is none of the decentralized exchanges are then actually fully decentralized, right? Which is also a bit, yeah. Reto, how do you see it from a Swiss perspective?
I think this is the point you mentioned is exactly what makes me think sometimes when I read again this FATF proposal, it's at least to a part wishful thinking, because if it's fully decentralized, you don't have this kind of central person doing the KYC. But I see obviously the regulator's perspective. They somehow want to catch this kind of institutions or yeah, contracts, I guess, because they are somehow replacing the existing financial system, and they want to catch as if they are if they are acting in the already existing centralized world, but it does not fit to the case. And on the other side, we have, at least from a Swiss law perspective, but I think it's also from the FATF, at least the international original perspective, that AML is actually always connected to the power to dispose actually over assets. This is the connecting point to doing KYC and having the contact to the client, the point of sale, the contractual relationship. This is the point where you have control, and you have control over the assets. That's why you are a financial intermediary. And I guess this is also the point. We are discussing this also in Switzerland in parallel with this a new DLT Act, which also changes some AML provisions. It's the same discussion in the end. FINMA tries to get institutions into AML which only support somehow transactions with virtual assets. But in the end, it goes back to who can we catch, and who let's catch him. In the
Exactly.
end.
And the traditional world always has at least a company or a person who's liable, who you can actually grab and catch. And now if it's decentralized, there is no one. So then the regulator or whoever tries to somehow find someone, right? Yeah.
And the regulator has, and also the legislators, they have not found the concepts to really capture decentralized structures in a good way. We see this also in other areas of our life, for example, with the autonomously driving vehicles, where we also discuss how do we regulate the liability if there's damage somehow by such a vehicle. It's somehow, these are the same questions in the end, and our established legal concepts are not ready as of now, but it's a kind of development.
Yeah, I 100% agree with you, and it's actually a nice idea to make the parallel of autonomous cars or self-driving cars. It's very similar. So we have self-driving or self-moving financial institutions, kind of, who are not financial institutions. Gabriel, we have a couple of minutes left to take questions. I want to give the opportunity to maybe pose 2 or 3 or whatever. 50 questions.
Exactly. I'll try to. I selected a few questions that I think was interesting. First one would be for Alexandra. Okay. How can one technically avoid working, and don't take it bad, Daniel, working with people located in USA, except blocking IP from US address? How can, let's assume that I have a DEX, I want to create a DEX, but I don't want to have the SEC nosing around because anyone could actually find a jurisdiction in the US if someone lives there. How do I avoid that, technically speaking?
So, I mean, technically speaking, as far as I understand, the blocking the IPs and then also doing some legal disclaimers that US-based investors are not authorized on the platform. As far as I know, that's all that's possible to put in place. There are a lot of ways to hijack those IP blocks. And I know of American-based users that use these techniques, such as a VPN, to kind of change the location of their connection and break those barriers. But yeah, I'm on the technical side, but I'm not actually on the development side, so I'm not aware of all the solutions maybe.
Okay. So maybe a question for Reto. Do we have, Daniel talked about the Ether Delta case. Do we have some DEX cases under Swiss law? Do we have FINMA who took definitive ruling on some case that are well known?
We have, the problem is a little bit that the cases are not publicly known. We certainly have some FINMA no action letters. That's when people or projects file with FINMA their view of its project and ask FINMA, is it regulated what we do or not? And such letters exist. We have one from a client in the house where actually the simple connection to the real world was that the project had wanted to establish a company in Switzerland, and the company would have earned a fee for every transaction being done over the DEX. And FINMA actually had the standpoint that this kind of company would be to read regulated and have a license, only because of this very small connex. So yeah.
This helped me to link it to the next question. So we know how traditional exchange can make money. How does a DEX make money if he cannot like even, you know, have his fee being vested without qualifying as a type of exchange? I mean, it's an open question to the board that was asked by Katarina. How does a DEX makes money?
Maybe
while still being a DEX.
I think it's important to say that although it's not a centralized entity, a DEX is a decentralized autonomous organization. And so as such, it's still an organization that's composed of kind of independent units. And so these units, so this organization is exchanging mostly via forum. And so all the decisions are passed by vote of token holders. So actually, it's quite possible to put in place fees for the exchange. And so the biggest decentralized exchange is Uniswap, but it was forked. So that means, so one of the reasons it's decentralized, one of the factors is that the code is open source. So that means anyone can read the code, copy it, duplicate it, and then create exactly the same thing over again, but as a competitor now. So that's what happened to Uniswap with SushiSwap. And so in Sushi, for example, there is the possibility to stake the Sushi token, which is the governance tokens that decides on everything. And when you stake it, you generate a return, you get part of the fees. And so you get kind of a fee accrual token, which is called XSushi. So it's completely possible to have a treasury, to manage that treasury, to direct funds to development or to growth or to different upgrades as a decentralized organization.
Okay, thank you. I have a question of my own. Thank you a lot, guys, for we're kind of reaching the time, and I had a question on my own, and I will take the opportunity to ask it. I feel like, you know, a biologist sometimes, we're kind of trying to draw up a new species. We're trying to take old stuff in our drawing to draw up this kind of new beast. And I have a question with regard to, if you were the regulators, how would you supervise, how would you monitor those kind of decentralized exchange? If you had a pen in your hand and you could like draft up a convenient way to regulate the DEX, how would you do it?
That's a tough question, but a very good question.
You have 2 minutes. So, someone for an answer? What would be the best way to regulate those entities in the end?
One way to start, and I think one of the problems of the regulators right now is just understanding what's happening, you know, and for me, like I've been working in blockchain now for 3.5 years, you know, at Aave nearly 2 years, but I'm still struggling to catch up with everything that's going on in the space and the degree of innovation. So yeah, I think before regulating, the real important thing is regulators hiring maybe experts that have really worked in decentralized organizations and understanding, yeah, like the challenges of decentralization, the risk of decentralization, because I think, especially like when you look at some rules over, for example, online information and the right to be forgotten, and there were kind of, the mindset is completely different than to centralized entity, and there really needs to be an evolution in the philosophy of the regulation itself.
I agree on that, and I just wanted to mention, I mean, if you see the FATF proposal on their latest guidance, you see that they don't differentiate between like a fully decentralized exchange and a semi-decentralized exchange. They just think, okay, a decentralized exchange needs to be regulated somehow. We need to like push them into KYC and AML direction. But I think they, as you said, Alex, they need to understand that there is like, it's not just one DEX and the rule applies to all. It's like, there is like some degrees actually of decentralization. And if a decentralized exchange is fully decentralized, I think then it should really fall out of scope as it is in Switzerland right now.
So thank you a lot, guys. I'll hand it over to Karin.
Yes, so I think we actually reached the time. So thank you, all of you. Thanks, Alex. Thanks, Daniel, and thanks, Reto. Thanks, Gabriel, as well. And thanks, everyone, for listening to our conversation. I hope you liked it. Feel free to contact us or to connect with us on LinkedIn. If you want to join the CVA or the regulatory working group, actually, then just feel free to contact either Gabriel or myself. We're happy to have very good regulatory and compliance specialists and legal specialists in the crypto space, so that we can contribute something to the whole environment space. Thank you so much, and wish you all a good evening. Bye. Bye-bye, guys.